If you have questions while I'm going through this, please feel free to submit those to the Q&A function. I'll see them come up. And then also make sure that at the end of this, you keep an eye out for an email from us with, it'll have some materials in it, little handy chart on planning for the home with Medicaid, just some big, really common myths that we run into with the home in particular, or real estate in particular, I should say. And then also there's a place for you to fill out feedback that you have and let us know if you'd like to come in and talk with one of us for a complimentary initial consultation. So again, those are complimentary. They don't cost you anything to come in and talk to us. And we schedule them for about 2 hours. And if you have anything that you want to talk to about Medicaid, or talk to one of us about Medicaid, or have concerns for your own family related to that, please feel free to let us know that you'd like to come in. And just as a heads up, we won't be doing one of these next week. We'll have our Green Bay public seminar, so our wills versus trust seminar. So if that's something you're interested in attending, please sign up for that sooner rather than later. I know seating can be limited. All right. So to get started, when we're talking about common Medicaid myths, I think a lot of times they do come up around the home, but this can really apply to a lot of different assets. Probably one of the biggest myths that we run into is, or maybe not necessarily a myth, but just not necessarily the best advice, depending on the situation, would be whether or not somebody should just put the home in the kid's name, take it from their name, put it in the kid's name, make sure that they transfer that asset over. And once it's out of their name and they're past the look back period, that, well, everything's, good to go and they don't have to worry about it. The problem with gifting the home or transferring the home over to the kids and not selling it to them or some other way to protect that home is that there's a lot that can go wrong with that. So first and foremost, of course, it's still a divestment for Medicaid. So Medicaid has what's called a 5-year look back rule, which means if you apply for Medicaid benefits, they will look back the previous 5 years to see if you gave anything away for less than fair market value. So if you sold the home for $1, you just transferred it with a deed without selling it, that's a divestment. And that goes for all sorts of assets. So that can still be a risk, but even if that's not the concern, there are 3 really big reasons why gifting the home to the kids is not as safe as you would want it to be. The first is that it's a huge loss of control. So when most people gift their home over to their kids, they have no other sort of agreement in place saying that they have the right to reside in the property, or that their kids can't sell the home or charge them rent or anything like that. And in theory, if one of the new owners decided to start charging the previous owners rent for living in that property, or to evict them for not paying rent, they have every legal right to do so. They have no obligation to just let that person live there. So it's a really big risk to just transfer that property over without any other sort of agreements in place. That can be a really big, problem for people who maybe don't trust the people they're giving their home over to as much as maybe they otherwise would. And I hope your kids would not do that to you, or the people that you're transferring that home over to wouldn't do that to you. But it is a big risk, and it legally is something that they can do. It's not illegal for them to start charging a tenant rent, or have some other sort of agreement in place. So just be very aware of that before you just gift the home over. Make sure you want other agreements in place. You want other ways to do things to make sure that you yourself don't get evicted from your own home. The second really big problem with just transferring the home over to the kids is one of taxes. So it's not that the transfer itself will automatically create a tax for the recipient or for the person transferring the home. It's that it may cause tax problems later on. When you buy your home, the IRS basically says, or if you built your home, whatever you've monetarily put into your home, that's what the IRS says your cost basis is. So your cost basis is how they figure out what you will have to pay in taxes when you sell it. Now, with your primary residence, you have an exclusion from capital gains tax of $250,000 per owner, as long as those owners both live in the property, right? So when you sell your home, you're very unlikely to have a capital gain, taxable capital gain that you have to pay any taxes on at all. because you would have to have a gain of more than $250,000 on the property for a single person and $500,000 for a married couple, right? So most of us don't have to worry about paying capital gains tax on our own property or residence as we sell it. But non-residents or second homes or vacation homes or just additional real estate that the person does not live in, if you sell those properties, you don't get that same $250,000 exclusion. So the issue there is that if there's any gain at all, your kids, once they sell the home, if they're not residents of the home, will have to pay capital gains tax on the difference between their cost basis and what the fair market value was that they sold it for. Now, the reason this is an issue is because when you gift it over to your kids, your cost basis transfers over to them. So the IRS says, well, they paid for it, whatever you did. Meaning that if you bought your home a really long time ago, 40, 50 years ago, and then you transfer it over to the kids, their cost basis is going to be incredibly low compared to what the fair market value actually is. What's a better way to leave property to somebody is to have them inherit that property, because then when they inherit the property, they get a step up in basis, which means that the IRS will adjust that cost basis up to fair market value at the date of death. So that means that they then, if they sell it very quickly, won't have much or maybe any in terms of capital gains at all. So they can really avoid a lot of tax issues by inheriting the property as opposed to having it gifted to them. If they buy the property, their cost basis is whatever they paid for it. So that, can avoid that issue as well, but of course they have to pay for it. So it is much better to have somebody inherit a property than it is to gift that property over to them in terms of what tax situation they're going to have after you pass away. The third and probably the most crucial reason I would think to avoid just transferring the home over to the kids in their own name is that it can create a lot of extra liability that you otherwise wouldn't have. So when something happens to the owner of a property, it also happens to the property itself, right? So what I mean by that is if an owner of a property is sued, they get divorced, they pass away, they have file for bankruptcy, they have creditor issues, that happens to what they own as well, or what they own is at risk for those things. So you, as the original owners of the home and residents of the home, have some homestead exemptions and protection to provide some protection against those things. It's still not, airtight or perfect or going to cover all of it, but it's better than nothing. You also only have one or two people's liabilities attaching to that property potentially. When people gift the home over to their kids, they open up that home to the liabilities of whomever they're gifting it to as well, which may or may not be this, more people than previously owned it if they gifted equally to their 4 kids, for example. But because those children may not be residents of the home anymore, they also don't get the same sort of homestead exemptions or protections against certain liabilities. And again, those are not the best protections in the world, but at least it's better than nothing. And you don't want to open up the home to more liability than it was otherwise subject to. So there's some examples where real life examples where people have gifted the home over to the kids. They never needed long-term care, or they were well beyond the 5-year look back rule. So it wasn't a problem for that. But then in the time between when they gifted it over and when they passed away, a couple of the kids passed away as well. And that portion of the home went in accordance with that child's estate plan. So it maybe went to a spouse or a grandchild or, somebody they didn't actually initially intend to own the property. And sometimes that doesn't create any issues, if everybody gets along well, or maybe it's what they would have wanted in that circumstance anyway. But what it doesn't do is it does not protect against unforeseen circumstances, like if somebody does have a creditor issue or they have a substance abuse concern where, if they were to sell that property and suddenly have an influx of cash, they're very unlikely to not use it to, on their substance abuse issue. So it's something that you want to provide protection for. And those 3 issues that I mentioned, the loss of control, the tax planning issues, and the risk, the liability risk that you create by, just transferring the home over, can all be dealt with through things like irrevocable trusts, where the trust grants an occupancy right to the the original owner so that the trustees can't evict them or charge them rent, right? Or sell the property without their permission. It is part of their estate, so they get a step up in basis when they pass away. And there's usually provisions, as long as the irrevocable trust is drafted well, that would say, if any of our beneficiaries who inherit this property have any number of these issues that would lead to them not being a good fit to be in charge of it, we can protect the inheritance from those sorts of liabilities. So you'd much rather use a structure like that than just gifting it over. Gifting it over seems very easy initially. I mean, it takes less effort to do that initial transfer, of course, but that's not necessarily better. And often it is not better at all. So there are, varying schools of thought on that, of course, but they just don't provide the same protection that you would get through an entity like an irrevocable trust. Speaking of the home and that sort of transfer, a really big myth, or I think more just out of date advice that we see a lot, is that life estate deeds are a good way to transfer the property or protect the property from long-term care expenses. If you're unfamiliar with what that means or what a life estate deed actually is, life estate deed is sort of like saying, I transfer a percentage of my interest over to those people, and I retain some portion of interest in it. And when I die, it will transfer over to them, at death. And that percentage of ownership interest that each person has is actually based off of the original owner's life expectancy. So as the original owner gets older, they get less and less and less ownership, and more transfers over to the people they've left that property to. So they own more and more and more. And then it transfers without the use of probate and avoids, that sort of issue. But the issue is that previously, prior to a rule change, they used to protect against what's called estate recovery. So what estate recovery is when Medicaid can go after what somebody owns when they pass away and say, based off of what we paid out for that person's care, we're going to recover against, the assets of the estate and take what we're owed. Life estate deeds prior to August 1st of 2014 used to protect against that as well. But any life estate deed that was drafted post August 1st of 2014, so 2014, does not protect against estate recovery anymore. So I've seen in the last, couple months, a few of these that were drafted actually, 2015 or 2016, 2017. One was 2018, actually. So it's not that they don't, transfer on death still that same way, but what they don't protect against is for Medicaid to come in against the estate and take what they're, owed from that person's share of the estate. So it's very important for you to know that if you're doing that planning, if you have a life estate deed drafted after August 1st of 2014, that you know that it is potentially at risk for estate recovery should you need any sort of Medicaid assistance. The old ones were grandfathered in, but there's still some issues with those in terms of, tax planning for if it's sold during life, or, in terms of if that original owner needs to sell the property and then use it to buy a new property, they're only entitled to the percentage that they actually retain at that point, not the overall value that they sold it for. So these were never really great options, in my opinion, but it's something that people did very commonly, and unfortunately people are still doing them, probably just because they're not up to date on the rules. So be very wary if you have a life estate deed that was done after August 1st of 2014. And there's part of the reason that's a myth is there's still advice that you see sometimes, or old articles that maybe somebody's read that say this is a perfectly valid way of doing it. So just be very cautious and always make sure you talk with an elder law attorney before you make that sort of decision. In regards to other sort of Medicaid myths, though, so not just the home, but other sort of planning misconceptions. I mentioned the 5-year look back rule. I think a really common myth we run into is that it's going up to 7 years. I have not heard anything about that. Nobody that I know of has heard anything about that. I think it's just a concern because at one point it did go up from 3 to 5. So, people think, well, they're just going to make it longer at some point. And they may. That's always possible, I suppose. But there is currently no talk of that happening. So I wouldn't worry too much about that going up to 5 years. In regards to the look back period, one of the biggest issues we run into with people violating that look back period or creating a divestment during the 5-year rule is doing things or making transfers that they think shouldn't be divestments. They don't think of them as divestments, but they otherwise end up being divestments and creating a problem for if they need care and need assistance that Medicaid won't pay for them for a period of time. One of the biggest myths and the most common questions I get is, isn't there some amount that you can gift every year that is okay, that it won't cause a problem for Medicaid? And the unfortunate answer to that is Medicaid says any gift that you make, in theory, could be a divestment. There is no amount for Medicaid that you can gift. And where people get that idea is from the gift tax exclusion amount, which currently is $16,000 per person per year. So in theory, you could gift $16,000 to everybody you know and not have to file a gift tax return. All that means, though, is that you're not lowering your end of life exemption, which is currently set at 12.06 million by any amount that you've gifted. If you go over the $16,000, say you gave $20,000 away to somebody, you would have to file a gift tax return, which would lower that 12.06 million by $4,000 because you went over by 4. But the IRS rules and Medicaid rules, they don't always play nice together, and often they don't. Medicaid does not care that that's an IRS rule. For Medicaid planning, if you gift any amount away, it's very possible that they will look at that as a divestment. There are some gifting exemptions, but I would not make that gift with the assumption that you're somehow not creating a problem for Medicaid. Always be aware that any sort of gift is going to be presumed to be a divestment, and you have to argue that it is not, that it was either, falls under an exception somehow, or, was a pattern of giving that you had, but it's very difficult to make that argument. So don't gift any amount thinking you're getting away with it. If you ask how, if you were to ask me, how do they know how much I gave away? Well, because you have to tell them. And if you lie on that application, it is fraud. So it's not advisable to do that. So you have to tell them everything. Otherwise, that's a problem too. So don't think that you can just hide that gift and nobody will find out about it. It's same sort of reason of how would somebody know if I make a withdrawal from my account where that money went? Well, they'll presume it to be a divestment, and you have to argue that it was not. With gifting, what things can be considered gifts that you otherwise wouldn't anticipate too. So just to be aware of things that you may be doing that are technically divestments for Medicaid, should you need to apply for it within the next 5 years. Things like paying a loved one for care without the proper documentation, right? You're technically paying them for a service they're providing, which for Medicaid purposes should seem like, well, you're getting something for fair market value in exchange. But unfortunately, without what's called a caregiver agreement, which is basically a notarized caregiving contract with a family member saying, I'm paying you and you're providing X number of hours per week of care for me at this hourly rate. Without that agreement in place, any payments to a family member, even for a purpose like that, would be looked at as a divestment. And it is very difficult to prove otherwise without that caregiver agreement. And unfortunately, these can't be retroactively applied either. So you can't do it right before you apply for Medicaid and say, oh, by the way, all those previous years of payments were part of this. It has to be from the start to, going forward. It's no longer a divestment if you have that right caregiver agreement in place, the proper documentation, but you can't retroactively apply it. Those sorts of payments are, they don't seem like they should be divestments because, the rule of a divestment is if you're gifting it away or not getting something in exchange for fair market value, right? That could be a divestment. Well, you're paying for care at fair market value rate potentially, or even under, and that seems like it shouldn't be a divestment. But just because of the way those rules work there, you need that notarized caregiver agreement in place to prevent that from being the case. Another really big myth or problem that people run into is that they end up, paying for care or giving gifts or reimbursements for people in ways that can be looked at as divestments as well. So what I mean by that is even if the caregiving child is going out and buying mom and dad's groceries for them, and mom and dad are just paying them cash in exchange, even though it's an actual reimbursement, that is not the best way to avoid that being looked at as a divestment for Medicaid. If you're buying groceries for a parent, it's much better to actually do that as, say, a power of attorney for somebody and use their actual debit card or credit card, right? Having the authority to do that, of course, using it directly, because then there's an actual paper trail, tied to the bank account or tied to the statements that shows to Medicaid that you have, it was a fair market value exchange, you were buying groceries. They don't question those things, and nor should they. But what they will question is if you went out and bought groceries for your parents, they reimbursed you for it later, that would potentially be looked at as a divestment. And with a lot of these things, you have the ability to defend yourself on those allegations, of course, but the risk is that the presumption is that it is a divestment, and the burden is on the individual to prove it was not. And that's not necessarily a place you want to be in when you are in need of care and need payment assistance from Medicaid. You don't want to risk not getting that assistance when you otherwise need it. So just be very careful in terms of how payments are being made, or what sorts of gifts you're making to somebody, because there's no amount that you can give, like I said, that's not going to count as a divestment if it's a gift. Those sorts of things are always a concern. I mean, people maybe have tendencies to give gifts or to charitable giving, and there's, like I said, the ability to show that maybe somebody had a pattern of giving, but it's not necessarily something you want to rely on. It can be, difficult to prove under the best of circumstances. So, with gifting in general, you always want to talk with an elder law attorney before you actually, engage in gifting, especially for the purpose of, Medicaid planning. You don't want to rely on what you've read online or what someone down the street told you, or, what can and can't be done, because that can be very risky if you're not dealing with or getting that advice from somebody who's up to date on the rules, or, has background in that area, right? Always make sure that you're dealing with that. With common Medicaid myths, you deal with a lot of bad online information, unfortunately, as you do with a lot of things. So when we're talking about when you should do this planning, another really big myth is that, unfortunately, if you don't have 5 years, that there's nothing that person can do. That, well, too bad, we don't think we have 5 years, so or they're already in care, so we have to spend all the money down, right? With the good news is that there are still things that somebody can do to protect about 50 to 60% of their assets, even once they're already in care, so that they don't have to spend down to everything, and that they can use that money to supplement care or pay privately longer, potentially, if they need to for that facility. So it's very important just to get advice while something can still be done, as opposed to thinking it's too late. 5-year look back rules are so that if you have time to plan in advance, you can do so. But if you don't have that time to plan in advance, there are still things that you can do. So in terms of spouses needing care, there's a lot of misconceptions about what is or is not available for the surviving spouse or the healthy spouse to keep. Thankfully, the surviving spouse actually gets to keep certain assets that they don't have to spend down on their spouse's care. A really big one that is very beneficial depending on the situation would be the healthy spouse gets to keep all of their qualified retirement accounts, things like 401ks, IRAs, 403bs, any of those, the Roth variations of them. All of those in the healthy spouse's name are unavailable for the other spouse's care. And the primary residence does not have to be sold as long as one of the spouses is still living at home and is healthy and not in need of Medicaid. So there's a lot of bad advice about that, or misconceptions that, well, I have to, half the home's at risk, or, we have to sell the home and use it on care until we're down to nothing. And that's not the case in Medicaid, for Medicaid in Wisconsin. The healthy spouse gets to keep quite a bit more than you would otherwise expect. Where spousal myths tend to come in quite a bit, though, is that, can I just choose not to leave my assets to the surviving spouse? So if the healthy spouse dies first, are there things that I can do to avoid having those assets kick my surviving spouse off of Medicaid, or protect those assets for them? The good news is there are things that can be done for that, but it's not done by skipping the spouse and going directly to the kids. So if you were to say, I'm not leaving my IRA to my wife, I'm leaving it directly to my two kids, that would actually be a problem for the surviving spouse, the wife in this example, if they were in need of Medicaid assistance, because that's what Medicaid refers to as a divestment by death. You have to leave everything to or for the benefit of your surviving spouse. Otherwise, that surviving spouse would have a divestment against them for their own Medicaid assistance. There are planning options that you have to protect those assets from spend down, or not force the surviving spouse to be kicked off of Medicaid and spend back down to, at that point, $2,000 of their own assets. But that is a particular type of planning that has to be done, at least in Wisconsin, through a will for that surviving spouse or the deceased spouse that will protect those types of assets from the surviving spouse's long-term care. So with those types of things, there are things you can do to protect those assets. You're not out of luck, but you have to do it the right way. You can't do it by skipping the spouse or just not leaving it to them, or protecting those assets by not leaving it to them is not an option. You have to leave it for their benefit in certain ways, but there are ways to do that that also protect those assets. With married couples as well, especially second marriages or later in life marriages, a really common misconception with Medicaid is that if you have a marital property agreement or like a prenup, right, saying that these are my assets, those are your assets, and if we get divorced, that's what we get to take with us, and we don't have to leave them to each other's kids or to each other if we pass away. A lot of people think that, well, because that's how that would work for marital planning, that then you don't have to use any of your individual assets on your surviving or on the other spouse's care needs for Medicaid spend down. Unfortunately, Medicaid does not care if you have a prenup in place. They don't care that you have, certain assets on one side of the, that's individual property for the healthy spouse. If it's an available asset according to Medicaid, doesn't matter if there's a prenup in place for that. Now, marital property agreements are very good planning for a lot of reasons, but don't do that thinking that somehow splitting those assets is going to be helpful, by qualifying them differently if you don't do other planning with it, because it is not, unfortunately, exempt from suddenly like being available for that other spouse's care. So with Medicaid planning, like I said, most of where this bad information comes from is online, or somebody heard something from someone else. So the biggest thing that you can do to avoid running into trouble is, if you have time to plan in advance and you have that concern, talking to somebody who solely practices in estate planning and elder law, and focuses their planning on that, or their practice on that rather. Somebody who stays up to date on these rules is very important, because they do change occasionally, although not as commonly as some other rules change, but they do change. And always make sure that you're doing things in a way that won't cause problems later on, or accomplish your goals of possibly protecting assets without losing too much direct control over things, or without losing other protections that you would otherwise have. So I'm not seeing any questions, but just again, if anything I talked about today raises concerns for you or your family, just know that you can let us know that you'd like to set up an initial consultation. They are complimentary again, so please feel free to come in and talk to us if you have concerns, especially about long-term care. And even more so if you have a loved one who may need care very soon, or is already in need of care, and you didn't realize that there were things you may still be able to do. That's even more important that you come in and talk to us. Again, next week is our public seminar for wills versus trust in Green Bay. So if that's something you're interested in, please feel free to sign up for that. Again, do so more in advance on that one, because I know sometimes seating is limited with the facility that we do the presentation in. Otherwise, I will let you guys go enjoy the nice day, and I will hope to see you guys next time.